Mr. Pistorius, you may remain seated. I'll tell you when to rise. In 2013, the accused stayed at house number 286, Bush Willow Street, Silverwood Country Estate, Silver Lakes. The house was a double-story with a main bedroom on the first floor. The accused slept in the main bedroom, which had en-suite facilities, that is, a bathroom and a toilet. To reach the bathroom from the main bedroom, one had to walk through a passage. Although there was no door separating the main bedroom from the bathroom, there was a door to the toilet that opened to the outside, that is, into the bathroom. The toilet was a small cubicle. The main bedroom had a sliding door that led onto a balcony. There were blinds on the windows and thick curtains which hung on the windows and the sliding door. When the blinds were closed and the curtains were drawn, the main bedroom was dark. On 13 February 2013, the accused spent the evening in his home with his girlfriend, Riva Steenkamp. In the early morning hours of 14 February 2013, the accused shot and killed Steenkamp, the deceased. At the time the shots were fired, the deceased was inside the locked toilet. As a sequence to the above, the accused was charged with the murder of Riva Steenkamp, read with the provisions of Section 51, subsection 1 of the Criminal Law Amendment Act, number 105 of 1997. In addition, he was charged with the following counts. Count 2, contravention of Section 120, subsection 7 of the Firearms Control Act, number 60 of 2000, in that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 7, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act, 60 of 2000, discharge of a firearm in a built-up area or any public place. The indictment carries on in that on or about 30 September 2010, and while traveling in a vehicle with other passengers on a public road or near Modderfontein in the district of Kempton Park, the accused did unlawfully discharge a firearm without good reason to do so by firing a shot with his own 9mm pistol through the open sunroof of the car they were traveling in. Alternative to count 2, contravention of Section 123B of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 3B, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act, 60 of 2000, reckless endangerment. In that on or about 30 September 2012 and at or near Modderfontein in the district of Kempton Park, the accused, in the circumstances mentioned in count 2 above, discharged a firearm, to wit, his 9mm pistol, with reckless disregard for other passengers in the car, and or people in the vicinity. Count 3, contravention of Section 120, subsection 7 of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 7, read with sections 1, 103, 121A, section 121, read with Schedule 4, and section 151 of the Firearms Control Act, 60 of 2000, discharge of a firearm in built-up area or any public place, in that during January 2013, and at Thatcher's Restaurant, Melrose Arc, in the district of Johannesburg, the accused unlawfully discharged a firearm, to wit, a Glock 27 pistol, without any good reason to do so. Thatcher's Restaurant is a public place. First alternative count to count 3, contravention of Section 123A of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 123A, read with sections 1, 103, 121A, section 121 read with Schedule 4, and section 151 of the Firearms Control Act 60 of 2000, negligent damage to property. In that on or about January 2013, and at or near Thatcher's Restaurant, Melrose Arc, in the district of Johannesburg, the accused negligently used the firearm, to wit, a Glock 27 pistol, and caused damage to the floor of the restaurant. Second alternative to count 3, contravention of Section 123B of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 123B, read with sections 1, 103, 121A, section 121, read with Schedule 4, and section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. In that on or about January 2013, and at or near Thatcher's Restaurant, Melrose Arc, in the district of Johannesburg, the accused discharged the firearm, to wit, a Glock 27 pistol, at a table in the restaurant among other patrons, in a manner likely to endanger the safety of the people at his table and or other patrons and the property of the restaurant. The accused had, in discharging the firearm mentioned, shown a reckless disregard for the safety of the patrons or property of the restaurant. In count 4, contravention of Section 90 of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 90, read with sections 1, 103, 117, 121A, section 121, read with Schedule 4, and section 151 of the Firearms Control Act 60 of 2000, and further read with section 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition. In that on or about 16 February 2013, and at or near 286 Bushwillow Street, Silverwood Country Estate, Silver Lakes, in the district of Pretoria, the accused did unlawfully have in his possession ammunition, to wit, 38 times 38 rounds, without being a holder of a license in respect of a firearm capable of discharging that ammunition, b, a permit to possess ammunition, c, a dealer's license manufactured manufacturer's license, gunsmith license, import, export, or in-transit permit or transporter's permit issued in terms of this Act, and D, or is otherwise authorized to do so. The accused pleaded not guilty to count 1 and handed in an explanation of plea in terms of Section 112 of the Criminal Procedure Act 51 of 1977. He also pleaded not guilty to counts 2, 3, and 4 and the alternative counts. The accused was represented by Mr. B. Rue, SC, and K.C. Oldwage. Mr. G. Nell and Mrs. A. Johnson appeared for the state. I sat with 2 assessors, namely Mrs. J. Hansen Dutoy and Mr. T. Mazibugo. Explanation of plea. In his explanation of plea in respect of count 1, the accused described the incident as a tragic one, which occurred after he had mistakenly believed that an intruder or intruders had entered his home and posed an imminent threat to the deceased and to him. The following extract is from the explanation of plea. I quote 4.1. During the early hours of the morning, I brought 2 friends in from the balcony. I had shortly spoken to Riva, who was in bed besides me. 4.2. Unbeknown to Riva, to me, Riva must have gone to the toilet in the bathroom. At the time when I brought in the friends, closed the sliding doors, and drew the blinds and the curtains. 4.3. I had the bathroom window sliding open. I believed that an intruder or intruders had entered the bathroom through the bathroom window, which was not fitted with burglar bars. 4.4. I approached the bathroom, armed with my firearm so as to defend Riva and I. At that time, I believed Riva was still in bed. 4.5. The discharging of my firearm was precipitated by a noise in the toilet, which I, in my fearful state, knowing that I was on my stumps, unable to run away or properly defend myself physically, believed to be the intruder or intruders coming out of the toilet to attack Riva and me. There was no explanation of plea in respect of counts 2, 3, and 4. Admissions in terms of Section 220 of the Criminal Procedure Act 51 of 1977, in brackets, the CPA, close brackets. Admissions in terms of Section 220 of the CPA were handed in by agreement between the parties. In respect of count 1, the admissions made by the accused concerned, inter alia, the identity of the deceased, the date, the scene, and the cause of death. The accused also admitted that the gunshot wounds were inflicted by him, that the body of the deceased sustained no further injuries from the time of death until the post-mortem examination was conducted on the deceased body, and that Dr. Seyman conducted the post-mortem examination and correctly recorded his findings on Exhibit B. There were no admissions made in respect of count 2. In respect of count 3, the accused admitted that a shot went off while the firearm was in his possession. In respect of count 4, the accused made an admission that at all times relevant to the count, he had not been issued with a license to possess a .38 caliber rounds of ammunition. I now deal with the summary of events. In respect of count 1, the state case was that the accused and the deceased had had an argument, and that the accused had then intentionally shot and killed the deceased, who had locked herself in the toilet. To support its case, the state called a witness, Mrs. Estelle van der Merwe, resident at the same complex as the accused, who awoke a few minutes before 200 hours in the morning to hear what she thought was a woman's voice. To her, it sounded as if the woman was engaged in an argument with someone. She could not, however, locate the voice nor tell what language was being spoken or what was being said. Shortly after 3 o'clock in the morning, she heard what she thought were gunshots. Mr. Charles Peter Johnson and Miss Michelle Berger, husband and wife, stayed in an adjacent complex about 177 meters away from the house of the accused. They both had screams that they interpreted as those of a woman in distress. Mrs. Annette Stipp, who stayed in the same complex as the accused, about 80 meters away, explained that she heard 3 sounds that she thought were gunshots. A few minutes later, she and her husband Stipp heard someone crying out loud and a man shouting for help. Mr. Michael Raymond Tlengetwa and his wife, Ayontle Hillary, were immediate neighbors to the left of the accused house. Mrs. Ntlengetwa woke her husband up to report that she had heard a bang. Soon thereafter, they both heard a man crying very loudly. Mrs. Ntlengetwa heard a man crying, "Help, help, help." At 3:16:13, Mr. Ntlengetwa called security to report the loud crying, but did not get through. He tried again at 3:16:36, and the call lasted 44 seconds. Caris Viljoenstander was another witness. She woke up and heard dogs barking. Thereafter, she heard a man shout, "Help, help, help." According to her, this was approximately 5 minutes before her father, Johann Stander, received a call from the accused at 3:19. Mrs. Ria Motswane is another neighbor of the accused. When one is facing the house of the accused, she is the immediate neighbor on the right. She awoke to hear a man crying out very loudly. She did not look at the time, but estimated that it could have been 3:20 when she woke up. The accused denied the allegations that he killed the deceased intentionally. He also denied that there was premeditation. The essence of the explanation of plea, as well as the evidence of the accused, was that when he armed himself with his firearm and fired through the toilet door, he was acting in the mistaken belief that the deceased, who was then unknown to him in the toilet, was an intruder who posed a threat to his life and to that of the deceased. He had believed that the intruder or intruders had come in through the open bathroom window. He had earlier heard the window slide open. At the time, he had his back to the bed just after he had awoken to bring in 2 fans from the balcony and to draw the curtains. He was therefore unaware that the deceased had left the bedroom to go to the toilet. Common cause facts, or facts which are not disputed. The following are common cause facts which relate to count 1 only. It is common cause that on 14 February 2013, shortly after 3 in the morning, screams were heard from the accused house, that the accused, while on his stumps, fired 4 shots at the toilet door, that at the time the shots were fired, the deceased was inside the toilet, that the door of the toilet was locked from the inside, that the door of the toilet opened to the outside, that is, into the bathroom, that 3 of the 4 shots struck the deceased, that the deceased sustained a wound on the right thigh, a wound on the left upper arm, a head injury, and a wound on the web of the fingers, and that the deceased died from multiple gunshot wounds. Also common cause is that soon after the shots had been fired, the accused called for help, that he used a cricket bat to break down the door, remove the deceased from the toilet to the hallway downstairs, that he was very emotional soon after the incident, and that he was seen trying to resuscitate the deceased. The issues. It is clear, therefore, that the issues are limited to whether, at the time the accused shot and killed the deceased, he had the requisite intention, and if so, whether there was any premeditation. Notwithstanding the limited issues, a lot of evidence was laid, and counsel argued extensively over 2 days. It shall not be possible, nor will it serve any purpose to rehash the evidence in detail. Hence the summary of the evidence above. It should also be fruitless to attempt to repeat every submission by counsel. This court has, however, taken all the evidence, and that includes all the exhibits and all submissions by counsel, into consideration. I may add that there were a number of issues which arose during the course of the trial. These issues took a lot of the court's time, and correctly so, as at the time such issues were important to the parties. The issues concerned were, inter alia, whether or not the police contaminated the scene, the length of the extension cord that went missing from the accused's bedroom, and the authenticity of photographs of items depicted in various exhibits. Having regard to the evidence as a whole, this court is of the view that these issues have now paled into significance when one has regard to the rest of the evidence. The reason for that view will become clearer later in this judgment. I proceed to analyze the evidence. I deal first with count 1. There were no eyewitnesses. The only people on the scene at the time of the incident were the accused and the deceased. Notwithstanding this fact, there was no dearth of witnesses who were willing to assist this court to determine what could have happened on the morning in question. Several witnesses gave evidence regarding what they heard or what they thought they heard at the time of the incident. A few could, in addition, tell the court what they observed after the incident. This court is indebted to all those witnesses, and this includes expert witnesses who sacrificed their time and resources to come and assist in this matter. The record of the evidence runs into thousands of pages. Thankfully, the nub of what is an issue can be divided into three neat categories as set out hereunder. Gunshots, sounds made by a cricket bat striking against the door, and screams in the early hours of the morning. For purposes of this judgment, gunshots, sound made by a cricket bat striking against the door, and screams will be discussed together as they are to an extent inextricably linked. It is common cause that on the morning of 14 February 2013, shortly after 3 o'clock, various people heard gunshots, screams, and other noises that sounded like gunshots emanating from the house of the accused. As stated before, various state witnesses had screams that they interpreted as those of a woman in distress. They had noises that sounded to them as gunshots. The defense admitted that there were shots fired that morning, but added that there were also sounds of a cricket bat striking hard against the toilet door, and that the noises sounded similar and could easily have been mistaken for shots. This was not contradicted. During the course of the trial, it became clear that some of the sounds that witnesses interpreted as gunshots were actually not gunshots, but sounds of a cricket bat striking against the toilet door. It was also not contradicted that the shots were fired first and that the striking of the door using a cricket bat followed thereafter. That there was a misinterpretation of some of the sounds is clear from the following. It is common cause that only 4 gunshots were fired by the accused that morning, yet some witnesses stated that they had more than 4 shots, while others had less than 4. This can only mean that some of the sounds that were heard were interpreted as shots could have been from the cricket bat striking against the door. It could also mean that some of the witnesses missed some of the sounds that morning, either because they were asleep at the time or their focus was elsewhere. For example, a witness could have been on the phone at the time. Significantly, Ms. Berger refused to concede that she could have missed hearing the first sounds, that is the shots, as she might have been asleep at the time, and that what she heard was a cricket bat striking against the toilet door. The evidence of this witness, as well as that of her husband, Mr. Johnson, who sought to corroborate her evidence, was correctly criticized, in my view, as unreliable. I do, however, think that they were unfairly criticized for having made almost identical statements to the investigating officer, Captain van Aert. After all, they did not write their statements and had no say in the format of the statements. They merely related their version to Captain van Aert, who has his own style of writing and his own vocabulary. The witnesses could not have been expected to know why he wrote in the manner that he did and why he used certain words and in what sequence. Captain van Aert was the only one who could have explained that. He was not called to do so. That omission, therefore, cannot be used against the witnesses. I do not think that Miss Johnson and Miss Berger were dishonest. They did not even know the accused or the deceased, so they had no interest in the matter. They also did not derive any pleasure in giving evidence. They stated that they were at first reluctant to come forward to give evidence until after the bail application, because they thought it was the right thing to do. They simply related what they thought they heard. They were, however, genuinely mistaken in what they heard, as the chronology of events will show. In my view, it is absurd to conclude that the evidence of witnesses must be rejected in its entirety merely because the witnesses failed to describe the events in exactly the same way. In any event, contradictions do not automatically lead to the rejection of a witness's evidence, as not every error negatively affects his credibility. Before determining the credibility of a witness who contradicted himself or herself, a court has to evaluate all the facts, taking into account the nature of the contradictions, their number, their importance, and bearing on the rest of the evidence. In brackets, CS v. Mkhohle, 1990, Volume 1, SACR 95, capital A in brackets. It is easy to see why the witnesses would be mistaken about the events of that morning. The distance from which Berger and Johnson heard the noises put them at a distinct disadvantage. Both of them and the Sips were adamant that they, in addition to the shots, heard screams of a woman in distress. So sure was Johnson and his wife that a couple had been attacked in their own home that Johnson got up early that morning to do something about improving his own security at his home. However, this court has approached the evidence of every witness in this matter, not only that of Johnson and Berger, with the necessary caution. There is a very good reason for this. Factors such as how long a witness has known a suspect, if at all, proximity, visibility, mobility of the scene, the opportunity for observation, and duration of the incident play an important role and are always taken into consideration by our courts. In brackets, CS v. Mtetwa, 1972, Volume 3, SA, 766, in brackets, capital A, close brackets. In the present case, we are here dealing with sounds, identification, and voice or scream identification, as well as interpretation that experts refer to as intelligibility, something that is even more tricky in my view. There is no reason why the same guidelines used in identifying the features of a suspect should not be applicable to voice identification. In Kasu, none of the witnesses had ever heard the accused cry or scream, let alone when he was anxious. That in itself poses a challenge, as the witnesses had no prior knowledge or a model against which they could compare what they had heard that morning. Even Miss Samantha Taylor, who confidently stated that when the accused was anxious or agitated, he sounded like a man and not like a woman. had to concede that she had never heard him scream when he was facing a life-threatening situation. In any event, the evidence of Mr. Lin, an acoustic engineer, cast serious doubt on whether witnesses who were 80 meters and 177 meters away, respectively, from the accused house would be able to differentiate between a man and a woman's screams if the screams were from the toilet with closed windows. Also militating against the conclusion that it was a woman's scream that was heard that morning is the following. 1. At the time of the incident, there was no one else in the accused house except the accused and the deceased. Therefore, it could only have been one of them who screamed or cried out loud. 2. According to the post-mortem examination report, the deceased suffered horrendous injuries. Professor Gert Simon, who conducted the post-mortem examination on the body of the deceased and compiled the post-mortem examination report, marked Annexure GW715, noted 4 gunshot wounds. These were on the head, 1 on the right upper arm, 1 in the right groin, and 1 in the right hand between 2 fingers. In his evidence, Professor Simon described the wounds individually as follows. The nature of the wound on the right hip was such that, I quote, there would have been almost immediate instability or loss of stability pertaining to that limb or hip, close quote. He explained that a person could transport weight onto the opposite limb and stand only on one leg, but the probabilities were that the injured person would become immediately unstable. It would clearly also be a particularly painful wound. Asked whether the 2 injuries, that is the arm injury and the groin injury, were serious, he explained that both the injuries were so serious that either of them could have killed the deceased. The injury to the arm was particularly devastating as the shot had fractured and shattered the right upper arm. Describing the head wound, Professor Simon stated that that would have been an, I quote, immediately incapacitating injury, close quote. A person sustaining a wound of that nature would be almost immediately incapable of voluntary action of any kind. He or she would probably also be immediately unconscious. The respiratory functions would have been compromised substantially. There was also damage to the brain, as well as substantial fracturing of the base of the skull, but minimal blood in the airways. This suggested that the deceased probably did not breathe more than a few seconds after sustaining this wound. The shots were fired in quick succession. In my view, this means that the deceased would have been unable to shout or scream, at least not in the manner described by those witnesses who were adamant that they had heard a woman scream repeatedly. The only other person who could have screamed is the accused. The question is, why did he scream? His version is that he screamed after he had fired the shots when he realized that the deceased was not in the bedroom. That version has not been contradicted. The time of the screams and the reasons for the screams make sense when one has regard to the chronology of the events of that morning. The screams were heard just after 4 shots were fired and before the 3 sounds from a cricket bat were heard. I continue to explain why most witnesses got their facts wrong. The fact that this case attracted much media attention, especially soon after the incident, and the fact that it became a topic in many homes also did not assist. Almost every witness who was asked under cross-examination if he or she had followed the news relating to the events of 14 February 2013, or the bail proceedings, or the trial proceedings, responded positively. A few witnesses considered that they discussed the case with others before they took the witness stand. Mr. Darren Fresco, for example, who gave evidence for the state in counts 2 and 3, stated that when someone called him the day before he was to give his testimony to inform him that his name had been mentioned in court, he was curious and wanted to know the details. He therefore took the witness stand with foreknowledge of what he might be asked. I venture to say that Mr. Fresco was not the only witness with such a disadvantage. I refer to it as a disadvantage because it does affect the credibility of a witness, as a witness might unwittingly relate what he or she had heard elsewhere, as though he or she had personal knowledge of the event. I am of the view that the probability is that some witnesses failed to separate what they knew personally from what they had heard from other people or what they had gathered from the media. The last reason why this court had to approach the evidence of each witness with caution is that the incident happened in the early hours of the morning when most of the witnesses who gave evidence were in bed. Mrs. van der Merwe was in and out of sleep. Mr. Johnson, Ms. Berger, as well as Dr. and Mrs. Stipp were roused out of sleep by either screams or what sounded like shots. Ms. Berger described it as a confusing night, while Dr. Stipp got his times clearly wrong. It was not disputed that Dr. Stipp heard the first sounds, heard screaming or shouting, heard the second sounds, went to the accused house, and assisted Mr. Stander to call 911 in that order. Counsel for the defense submitted correctly that the evidence of Dr. Stipp was unreliable as to the times when different events in this matter unfolded. He submitted further that Dr. Stipp's evidence in some instances was tailored with the objective of assisting the state's allegation. I do not agree with this submission. Dr. Stipp had no interest in the matter and would therefore have no reason to tailor his evidence to assist the state. I do not believe that he colored his evidence against the accused. On the contrary, he showed no bias against him. He told this court that when he arrived at the accused house, he observed a distraught accused attempting to resuscitate the deceased, that he was praying to God to save the deceased, that as soon as the accused learned that he was a doctor, he implored him to do something. When asked if he thought the accused's distress appeared genuine to him, he did not hesitate to respond positively. The facts above have been set out to demonstrate the difficult terrain that this court had to traverse to arrive at its conclusion. It follows from the above that it would be unwise to rely on any evidence by the witnesses, and this includes those witnesses called by the defense who gave evidence on what they heard that morning without testing each version against objective evidence. Human beings are fallible and they depend on memories which fade over time. Thankfully, as it shall be clear from the chronology of the events, this court is in a fortunate position in that it has objective evidence in the form of technology, which is more reliable than human perception and human memory, and against which all the other evidence can be tested. Phone records which tell us exactly who made the call, from which cell phone to which cell phone, and at what time, were made available to this court, and we took full advantage of that. There is also a record of the duration of each call. It is significant that although most of the timelines were initially introduced into evidence by the state, it was the defense which analyzed the timelines and set out hereunder, and addressed the court on each. When I asked State Counsel if the timelines were common cause, his response was that the only recordings of, I'll rephrase. When I asked State Counsel if the timelines were common cause, his response was that only the recordings of the various calls were common cause, giving an impression that the rest of the timelines was disputed. However, there was no address forthcoming from the state to disturb the timelines as set out hereunder. In any event, one can safely use the phone records, which were made between 300 hours 15:51 and 300 hours 17 as a base to arrive at the approximate times when the shots were fired, when the screams were heard, as well as when the sounds of the cricket bat was striking against the door were heard. In addition, the accused's phone records are also available. A perusal of these records show that at 3:19:03, which was minutes after the sounds caused by a cricket bat were heard, which was approximately 300 hours 17, the accused was on the phone calling Stander. A minute later, he called 911. Thereafter, 1.5 minutes later, he called security. I now proceed to set out the chronology of events. 1. At 2:20, security activated guard track next to the house of the accused. 2. Approximately between 3:12 and 3:14, first sounds were heard. These were shots. 3. Approximately 300 hours 14/15, accused was heard shouting for help. 4. Approximately between 300 hours 12 and 300 hours 17, screams were heard, or screaming was heard. And 5. Approximately 300 hours 15, accused was seen walking in the bathroom. 6. 300 hours 15:51, the duration was 16 seconds. Dr. Stipp telephoned the Silver Lake security. 7, 3:16, the duration was 58 seconds. Mr. Johnson called and spoke to Strubenskop security. 8, 3:16:13, Mr. Michael Ntlengetwa made his first call to security. This call did not go through. 9, 3:16:36, the duration was 44 seconds. Mr. Michael Ntlengetwa made his second call to security. 10, 3:17, Dr. Stips attempted to make a call to 10-111. 11, 3:17, second sounds were heard. These were cricket bats striking against the door. 12, 3:19:03, the duration was 24 seconds. The accused called Johann Stander. 13, 3:20:05, the duration was 66 seconds. Accused called 911. 14, 3:21:33, the duration was 9 seconds. The accused called security. 15, 3:22:05, duration 12 seconds. Peter Baba, the security, called the accused. 16, 03:22, Baba, the security, arrived at the house of the accused. 17, approximately 3:22, Johann Stander and Karisi Felyun arrived at the house of the accused. 18, approximately 3:23/24, Dr. Stip arrived at the house of the accused. 19, 3:27:06, Johann Stander's call to 911 in the presence of Dr. Stip. 20, 3:27:14, Dr. Stips attempted to call security. This call did not get through. 21, 3:41:57, an ambulance arrived at security gate of Silverwood's estate. 22, approximately 3:50, paramedics declared the deceased dead. 23, approximately 3:55, police arrived at the accused house. The chronology above gives a feel of where various witnesses corroborate one another's evidence and where they contradict one another. An analysis of the evidence using the timelines as a basis will also assist this court to determine whether the state has proved beyond reasonable doubt that the accused had direct intention and premeditation to kill the deceased.
What's your time?
I'll take a 2 minutes break. We'll take a 2 minutes break. Court will adjourn.
Maar wie ook, hij is het door te lang.